Well, good afternoon, everyone, and welcome. Thank you so much for joining us today. I'll go ahead and get us started. For those of you who don't know me, my name is Emily, and I'm one of the co-founders at LADN, along with Sally, who is also joining us today. We're really grateful to have Alexis and Moselle here with us from Leland Law, and they're going to be leading this workshop on applying for Social Security disability benefits. So this workshop will be recorded and will be posted to LADN's YouTube page following the event. Before we hand things over to Alexis and Moselle, I just wanted to give a brief introduction of LADN for those of you who might not be familiar with our community and our organization. So we are the Los Angeles Dysautonomia Network. We're a 501c3 nonprofit organization dedicated to supporting Californians impacted by dysautonomia through mental health, community, education, and financial support. So we offer support groups to both patients and friends and family members. We do fun community building events like the movie night we just hosted on Sunday. And we offer wellness workshops such as our monthly mindful movement class. And our educational programs are designed to inform and empower those with dysautonomia. And you're joining us here today as part of our educational programming. Additionally, LADN offers healthcare access grants that help low-income dysautonomia patients afford vital healthcare. Our applications are actually opening on September 1st for our healthcare access grants, so please keep an eye out for that application next week. And you can find more information about our programs at la-dn.org. And one last exciting announcement. We're so thrilled that LADN has just opened its first community gathering space in the heart of Pasadena's Playhouse District. This is a really big step forward for our organization, and we're working really hard to turn this space into a community hub for patients and families that are impacted by dysautonomia. So if you'd like to help support our new space and our programming, we invite you to join us for our housewarming fundraiser, which is going to be on Saturday, October 3rd, and you can find a link to tickets on our website, la-dn.org. So I'd love to give a brief introduction to Alexis Leland and Moselle Leland Borraquez, who are here representing Leland Law, which is a family-run law practice which was founded in 1974 that is dedicated to representing individuals seeking disability benefits. Moselle is a managing attorney of Leland Law, where she focuses her practice on Social Security disability. She regularly represents individuals with complex and often poorly understood illnesses, such as dysautonomia, but also ME/CFS, fibromyalgia, long COVID, and more. Moselle has handled disability cases at every level of the adjudicated process. She's a member of the National Organization of Social Security Claimants Representatives and a past chair of the Orange County Bar Association Social Security section. And she's presented educational programs for patient advocacy organizations and support groups, including ME/CFS Initiative and long COVID communities. Alexis Leland is a Social Security disability attorney who represents individuals navigating the SSDI and SSI process, including those with complex conditions, again, like dysautonomia. She graduated summa cum laude from UCLA and earned her Juris Doctor from Stanford Law School, where she served as notes editor for Stanford Law Review and later clerked for a federal district court judge. Alexis represents individuals at all stages of the disability process, and we're so grateful to have both you here today to lead this webinar. Thank you.
Thank you.
Thank you.
So before I hand things off to the two of you, I did want to just mention a little bit about our Q&A session coming up. We are so excited to have you both presenting on such an important topic today, and I know we are going to have a ton of questions. So I just want to let everybody know, if you have questions in today's webinar, if you could put them in the Q&A box, which you will find at the bottom of your screen. That way you're welcome to use the chat to say hello to other people viewing the webinar, and then we can keep all of our questions organized. I also wanted to mention that this webinar is educational, and Alexis and Moselle are not able to provide legal advice. So please do keep your questions general as opposed to about your specific case. And then now, without further ado, thank you everyone for being here, and I will hand things off to Alexis and Moselle. We so appreciate you sharing your expertise with our community.
Thank you. Thank you for the introduction, Emily and Sally. So today we're going to explain the two different disability programs, the process Social Security uses to decide whether someone is disabled, And most importantly, what evidence tends to make a dysautonomia claim stronger? We'll also cover practical things that you can start doing now, whether or not you've filed or whether you're just thinking about filing. Let me go to the first slide, the next slide. So as you can see here, there are two different Social Security programs. Social Security Disability Insurance, which is referred to as SSDI, and SSI, or Supplemental Security Income. These are easily confused because, as the bottom of the slide says, both programs use the same medical definition of disability. The difference is entirely on the eligibility side. So starting with SSDI, or Disability, Social Security Disability Insurance. It's an insurance program. You have to earn coverage by working and paying Social Security taxes. Generally, this would be 5 of the past 10 years before you become disabled. There are some caveats. If you are under age 30, you may need fewer quarters of coverage, as they call them. There are no income or resource limits to qualify for SSDI. You just have to not be actually working. So for example, we'll talk about this more, but if you have any passive income from, let's say, mutual funds, stocks, or even rental properties, that will not disqualify you. As well, the monthly amount depends on how much you've earned and put into Social Security by way of taxes, and that would be called your earnings record. And it leads to Medicare. Additionally, SSDI can provide a benefit for your dependents, your children. SSI is a needs-based program. It's kind of like a welfare-based program. So this is for people with limited or no work history. It carries strict income and resource limits. It provides Medicaid, or in California, Medi-Cal, rather than Medicare, and it does not pay any benefit for your dependents. Some people can qualify for both at once. For example, if you worked but not for very long or didn't earn very much, then you may qualify for both, and that would be a concurrent claim. And so in this slide, I'm going to go into a little more detail about the different programs. So going back to the left side of the screen, SSDI. So first, you have to show that you are fully insured. That means that you've worked long enough over your lifetime to be entitled to a retirement benefit. And that amount of credits that is required will depend on your age. Then you must show that you are also currently insured, that you have worked recently enough. And again, that is roughly 5 of the 10 years before your disability began. And again, that rule varies by age. Now, what happens if someone stops working several years before applying? Well, we have something called a date last insured. That means the date that you have to prove disability began on that date or prior. So that can become one of the most important dates in a case. So you have to show your disability began on or before that date, and that can mean going back to older records and reconstructing your function at that time. It's also important to know that SSDI has a 5-month waiting period after you become disabled and disability is established where no benefits are payable. Additionally, you can be entitled to up to 12 months of retroactive or back benefits from the date of your application. Moving on to SSI, it requires no work history, but again, as I mentioned, the rules are strict, the financial rules. The most you can have in resources is $2,000 for an individual, $3,000 for a couple. If you have any income, there will be a dollar for dollar benefit reduction, and they will look at a spouse's income as well. So once we know which program applies, or if both apply, the next question is the health insurance. So let's look at this slide. And I apologize, there's a slight typo at the top. It's actually a 30-month wait. So as I mentioned, if you are applying for SSDI, you will be entitled to Medicare. but it doesn't start immediately. So take a look at this. Month 0 is the date that you prove you're disabled. Let's say January 5th of 2025. Okay, so it's not the first day of that month, so they're not going to count that month. It's going to be 5 full months later, or month 6, where you first get your Social Security disability payment. Now, when does Medicare start? It's not going to start for another 24 months. So that's 2.5 years or 30 months before your Medicare will actually start. So, and SSI recipients, again, will only qualify for Medicaid. Now, Part A is free if you have a certain number of quarters of coverage or work quarters. Part B has a premium, and this year it's about $202, and there is also an additional annual deductible. And those amounts do change annually. If you are in the situation where you qualify for both Medicare and Medi-Cal, though, you may not have to pay those premiums. So there could be a gap where you're not covered by insurance because there's this wait for Medicare benefits. So during that gap, people are relying on things like COBRA, a spouse's insurance plan, or some sort of marketplace plan like through Covered California or Medi-Cal. So this is something that you need to plan for. So this next slide talks about what's called the 80% ACE offset. Now, what happens if you're getting other benefits like state disability? We're very fortunate in California. Not a lot of states have state disability. State disability is much easier to get. We generally don't recommend hiring an attorney. It's usually pretty straightforward. So state disability can last up to a year. But that benefit could affect what you receive in Social Security disability benefits. So that's a public disability. So they have the public disability offset or the 80% ACE rule. The combined benefits from, say, state disability, workers' compensation, and Social Security cannot exceed 80% of what you used to earn on average. So if those benefits combined is more than 80%, your Social Security disability benefit will be reduced by whatever goes over that amount. People do always ask, well, what about private long-term disability, LTD, or VA benefits, or some sort of pension that they're receiving? Is that going to affect my Social Security disability benefit amount? Generally not. LTD is not going to affect it. VA benefits do not affect it, and private, any sort of pension generally will not affect it. It will only affect your SSDI benefit amount if it is a public disability benefit. Now, keep in mind, though, a private carrier, for example, long-term disability insurance carrier, generally does reduce what they pay because of receipt of SSDI. And I believe, okay, so that's all for that slide. Okay, so this slide is going to talk about, in general, filing a Social Security disability claim for benefits. There are 3 stages. So the first stage is the initial application where you file. And there's a lot of paperwork involved. They're going to send you a lot of documents during that process that they're going to ask you to complete. And I believe Alexis will go into detail later about completing these kinds of forms. But they'll send you things like a function report. They may send you a pain questionnaire, different things. And the next step, if you get denied, would be to ask for reconsideration. That's your appeal. This will be a fresh review of your file by the state agency, and they're supposed to have a separate individual and set of eyes review your case. However, even though you're supposed to have different people reviewing your case at the reconsideration level, there is about an 80% denial of claims. So only about 20% of the claims that were denied at the initial level are reversed and approved. So if you've gotten that far, you're likely going to have to go to the 3rd step, which is a hearing before an administrative law judge. And as I mentioned, most claims are unfortunately denied at the first 2 stages, and the hearing is where a lot of these cases are won. I think it's important to know this so that you don't get discouraged and give up, because in all honesty, I think that's what they're hoping for. The hearing is different because it's usually the first time you can really explain in real time what your daily functioning looks like. The judge can ask follow-up questions, your representative can present a theory of the case, and also cross-examine any experts like vocational experts. Keep in mind appeal deadlines. If you get denied at the initial level, there will generally be 60 days from the date of your notice to appeal, and that 60 days applies at any of these stages. So you want to appeal promptly. You don't want to have to start over, because if you start over instead of appealing, that can cost you a lot of time and possibly back benefits. So people are always asking, how long is this going to take? Well, this on this slide will tell you what Social Security officially is telling people is the average processing time by stage. This takes into account the entire country, so that might not be completely accurate for California. And as you can see, this is actually a lot better than it was in previous years. So if you see this, it says the initial level is going to take about 6 months. We still have cases that take up to 12 months at the initial level, so important to keep that in mind. Reconsideration, they're saying, is about 7 months right now. Sometimes we are getting them back faster, but they still, again, can take up to 12 months or occasionally more. The hearing stage, they say, is taking about 8 months. However, in my experience in California, it's taking probably closer to 9 months. So, we say if your case goes to hearing, plan for well over a year. I would say plan for up to 2 years, if not a little more. So, what is the definition of disability for a Social Security case? Social Security's definition is not necessarily what you would expect, and it is stricter than what most people expect. No, you don't have to be completely bedbound, but you must show an inability to engage in what they call any substantial gainful activity due to a physical or mental impairment expected to result in death or last at least 12 continuous months. Sometimes people apply too soon after they stop working and get an immediate denial, because Social Security can easily deny that kind of a case and say, you haven't proven that your condition is going to last 12 months. So that sometimes happens. So what does it mean by any substantial gainful activity? The question isn't just whether you can return to your old job, but whether you can perform your old job or other work in the national economy on a sustained basis. There is no partial disability like there might be for state disability or workers' compensation. You either qualify or you don't. Now, what about flare-ups? And how does that play into proving that your disability is lasting 12 months or more? Well, if all you have is a severe 6-month flare, that will not satisfy the duration requirement. Yes, for a 6-month period where you can't work, you can qualify for state disability. You will not qualify on that basis for this federal Social Security program. However, a lot of conditions wax and wane. They're episodic in nature. You can still qualify if that's the case. So you don't have to be bedridden every day of the year. But the question is whether this impairment is persistent and whether the better days that you have are enough to be reliable and to function reliably across a normal work week and work month and work year. So if you're going to be absent on a regular basis, let's say at least 1 or 2 work days a month, they would not find you to be reliable. And so now Alexis is going to walk you through the 5-step evaluation process.
Thank you, Moselle. All right, so Social Security has 5 steps that it goes through when it evaluates a claim. And the first step is a gatekeeping question. Are you working? Are you engaged in what Social Security calls substantial gainful activity? If yes, the claim ends here. Social Security will deny you without ever reaching the medical evidence. If not, the evaluation will continue to the next step. All right, next, thank you. So, substantial gainful activity, or work that is substantial. It must involve significant physical or mental activity, and it is gainful when it's done for pay or profit. It has to be both. Earning above a set threshold generally means you are not disabled. In 2026, this threshold is $16.90 a month in gross earnings. What this means, practically, is that part-time work doesn't automatically end a claim. If your earnings fall below this threshold, you may still be found disabled. Social Security will look at your part-time work and the circumstances around it. Do you have reduced hours, extra breaks, help from coworkers, unusual flexibility, etc.? The other point to keep in mind is Social Security counts your gross earnings, not your take-home pay. It is possible that you can deduct certain impairment-related work expenses. These are some very limited expenses that make work possible. For example, modifying your car for a wheelchair, or co-pays for medication for your disabling condition. Ordinary transportation costs, health insurance premiums, these are expenses that don't qualify. This is something that we see a lot of mistakes that people make. They assume that you can deduct the way you can with the IRS. Social Security's list of allowable expenses is quite limited. It's also important to keep records and receipts. Self-employment is evaluated differently. As the last bullet notes, Social Security looks at the value of the services you provide to the business, not just what you paid yourself. And finally, there are unsuccessful work attempts. You may stop working because of your disability and then decide you want to try working again. If you go back to work, you can earn any amount, even above the substantial gainful activity threshold. And so long as it is less than 6 months and you are unable to continue because of your health condition, it is possible to argue that it is an unsuccessful work attempt and those months of work will not be held against you. Okay, so the next step in the evaluation process, Social Security will ask, is your condition severe? So Social Security will look at all of your conditions taken together and ask, do they significantly limit basic work activities such as lifting, carrying, standing, walking, maintaining concentration? You must also show that your condition is backed by medical evidence, not just your own reporting of symptoms. And this is an area where our dysautonomia clients sometimes struggle because they may lack a clear-cut diagnosis. However, even without a diagnosis, medical findings such as orthostatic intolerance, autonomic neuropathy, can satisfy this step. If you're still being worked up, the referrals that you're getting, medication trials, and follow-up visits will usually suffice to show to Social Security that you have a severe impairment. All right, so the next step, step 3, is the listing. Some of you may have heard of Social Security's Blue Book. Basically, this is a list of medical conditions that are severe enough to be disabling on medical grounds alone. And these listings are organized by body system. If an impairment meets every requirement of the listing or is medically equivalent to one, you're found disabled with no further steps. These listings are rather stringent, so not many people qualify under the listings. If that's the case, you proceed to the next part, which is an assessment of your residual functional capacity. All right, so step 4. Oops, sorry, the listings, sorry. That's great, thank you. So dysautonomia does not have a listing. There is medical equivalence, which is showing that dysautonomia plus another condition is equal in severity to a listed impairment. Social Security will look at actual findings, not just the diagnosis. And then path 2 is the most common path, which is the residual functional capacity, or RFC. If your capacity rules out your past work and all other work, you'll be found disabled. This evaluation relies on function evidence rather than, again, the name of a diagnosis. And either way, both paths rely on the quality of the medical record. Okay. Okay, so here are a list of some of the medical listings that our dysautonomia clients sometimes also may be found disabled under. The most commonly cardiovascular, neurological, immune, digestive, and mental. For this reason, we always ask clients about all of their medical conditions, not just the dysautonomia. We want to have a complete picture and, find out if there's any other criteria that someone might be approved under. Okay. In addition to those listings, there are certain rulings for medical conditions. Fibromyalgia and chronic fatigue syndrome are some of the most common rulings that we see with our dysautonomia clients. If you meet the criteria for either of these rulings, you can also be found disabled. Again, there's no ruling for dysautonomia. It's sort of an orphan diagnosis in that regard, but these are some other considerations for many of our patients. Okay. There is no required evidence for dysautonomia, and every case is going to be different, but the tilt table test or active stand test are the most relevant and commonly seen for dysautonomia. There are some other tests that we occasionally see. They're not terribly common though, but you can see them listed here: autonomic function testing, QSART, electrocardiogram. We don't recommend that you shop around for these tests. It really is something that's best left up to your doctor's discretion about what's appropriate for your specific situation. Okay, so
okay, sorry about that.
Is that, go ahead, Moselle.
Oh, no, I wasn't sure if you wanted me. So what about the full clinical picture for your case? A persuasive record is going to have 4 components to it. As we mentioned, there are other diagnoses or comorbid diagnoses that you have in addition to the dysautonomia. There's also going to be your treatment history. For example, A lot of individuals have fluid loading, salt loading, compression garments, beta blockers, medications like midodrine, fludrocortisone. And we also want to know, though, what your response was to those treatments. Also, another part of the record will be what acute events you've had, such as emergency visits, any syncope, falls, or injuries that you may have had. And lastly, we hope that your record will demonstrate the functional impact that your conditions have. For example, are they causing you severe fatigue, brain fog, exercise intolerance, post-exertional malaise or crashes, and a significant amount of time to recover? The treatment history is more useful when the record is detailed and says what is happening. If it just says something like you tried a beta blocker, that really doesn't tell a reviewer at Social Security a whole lot. We really would like it to be specific and say, what was the effect of the medication you tried? Or the medication was stopped due to side effects. Or it helped the symptoms briefly, but then faded. So this kind of information tells us more. So you want to make sure that you are giving your doctors this information and that your records have this information. So going back to residual functional capacity, which Alexis spoke about, the residual functional capacity is the most that you can still do on a regular and continuing basis, 8 hours a day, 5 days a week. So they're going to look at, well, first let's mention, what do they mean by sustained? That's a central word for dysautonomia cases because sure, many people can do something once, but the question is whether you can repeat it predictably and you can do it over and over again, 8 hours a day, 5 days a week, without causing significant worsening. So what are your physical limitations? For example, they look at how much you can lift and carry, how long you can sit, stand, and walk at one time and in an 8-hour day in total, if you are able to push and pull, and what your postural tolerance is. For example, a lot of our clients, just sitting is a huge problem for them, and they will start feeling lightheaded and have near syncope episodes and need to lie down. Now, we'll also look at any mental limitations, and it doesn't have to be because of a mental impairment such as depression or anxiety, but sometimes just the physical impairments will cause mental limitations. But in any event, they look at these areas: understanding and remembering, carrying out instructions, responding to supervisors, coworkers, also the public, and how do you handle workplace stress or pressure? Because it's very individual. Some people can handle more, some people less. And then finally, there are additional restrictions that need to be looked at. Do you have any limitations in heights or heat, machinery? Do you have syncope? Are you a fall risk? Again, what about fatigue or pacing or the need for unscheduled breaks? A lot of my clients have to lie down. There are no jobs that allow you to lie down generally unless they are providing you with an accommodation. So when you move on to the next step, or Social Security moves on to the next step in their evaluation, that's step 4, they're going to look at what your past work was. And again, they're just going to look at work that was performed within 5 years before you allege disability. So step 4 is asking, can you still do your past work? Social Security is going to consider the job that you did and how you actually performed it. They're also going to look at how it's performed generally in the national economy. So even if you had to lift, let's say, 50 pounds, but your job is normally done at what they call sedentary level, lifting very little, they will see if you can do that type of job. So it's very important, though, because a lot of this you don't need to know right now, but your age will be taken into consideration, your education as well. So we want you to be precise on your work history description. Don't puff up what your job was either. But we want you to be very precise on how many hours you had to stand or sit, what you had to lift and how much, any breaks that you normally had, if you had any supervisory duties, and also if you had any accommodations. Just don't assume that your job title will tell the full story. And as I mentioned, if you really were a hands-on worker, let's say a lead worker, you don't want to say you were just, a manager or supervisor, because then they'll think that your job was less physically demanding than it really was. So if they find that you cannot do your past work, Social Security will move on to the fifth and final step, other work. Can you do other work in this economy considering your RFC or residual functional capacity together with your age, your education, and your work experience? If you can do other work at this step, they'll deny your claim. If you cannot, you show that you cannot, then they award benefits. So at a hearing, for example, there will be a vocational expert or witness. And that person will be there to answer questions that are presented by the judge about jobs that an individual with various limitations can still perform. If you have an attorney, they will have the opportunity to cross-examine the vocational expert and try to eliminate the jobs that are presented by asking, for example, other limitations the judge might not have included, such as unscheduled breaks, excessive absences, reduced pace, a need to lie down, or safety restrictions. There are also a lot of nuances to the testimony that one of these witnesses gives. For example, they may give jobs that really don't exist anymore. So that's something that can be a bit tricky. So a lot of times people will research a little bit on the internet and they might ask us if they meet what's called the grid rules. The grid rules is a term that is used for the Social Security medical vocational guidelines, and Social Security will use that to help determine whether a person is disabled. What they do is they classify work by exertional range, shown at the top of this slide. So for example, sedentary work is lifting no more than 10 pounds, and it's mostly seated, at least 6 hours a day seated. Light work means you can carry a bit more, 20 pounds occasionally, 10 pounds frequently. But the big difference here is that you have to have the ability to stand and walk, let's say 6 hours or more a day. Medium, heavy, and very heavy work just means that you're carrying a lot more, or it's required, or that you're having to push and pull frequently or constantly. Dysautonomia RFCs often land at sedentary because of standing and mobility limitations and because of the risk of syncope. But why these rules matter, these grid rules matter, is once you get to age 50, the rules are softened somewhat. If you cannot do your past work and you are limited to a sedentary job or sedentary unskilled job, you should be found disabled. If you have past work that is sedentary, then it's a little more tricky. You have to show you can't do that work and you're limited to sedentary unskilled. So once you get to the next age category, which is 55 or older, the same results will apply, but you will be found disabled or grid either at sedentary or light unskilled work if you cannot do your past work. So Alexis, if you can tell us what claimants can do to build a strong record at the next slide.
Sure. So here are some important things to keep in mind. Most important, keep your appointments. Get regular treatment if possible. Gaps in care often are read as evidence of improvement. Report symptoms that affect your function. Presyncope, fatigue, brain fog, heat tolerance, post-exertional worsening, recovery time. You may also want to keep a symptom and activity log. Contemporaneous notes carry more weight than just a recollection at a hearing. Track the frequency, duration, and triggers, including what assistance you needed. Finally, document your medication side effects, dose changes, and any gaps with the reason for each. Now, on treatment gaps, if the reason for your lack of care is because it was unaffordable, unavailable, ineffective, or you just physically weren't able to get to doctor's appointments, tell your provider so that that reason can get documented in the medical records. A few more things that you can do to strengthen your case. Review your own records. Take a look at what your providers have actually written. This way, if you see that there are errors or that there are certain things that are missing, you can take action before that kind of hardens and there's nothing that can be done about it. If you have a good relationship with your doctor, you may ask them for specific work-related limitations. A diagnosis is not a functional limitation. So asking your doctor for their opinion on your ability to sit, stand, or need for taking breaks, those are all things that would be helpful. In our own practice, we tend to send questionnaires to doctors with those kinds of questions that are tailored to what Social Security is looking for. Finally, sometimes people ask about getting a functional capacity evaluation from a physical therapist. That can be helpful information, but there is a caveat. Physical therapists' opinions are not going to be persuasive in the same way that a doctor's opinion will be. So while it's useful information to have, it's preferable to have the opinion of a doctor on what you actually are limited to. Okay. So when you file an application for benefits, Social Security will send you a questionnaire about your daily activities, also known as a function report. These can either help or hurt your claim. They are compared against your medical records and your testimony. So a few things to keep in mind. Answer the question asked. Read each question carefully and respond to what's actually what they're requesting from you. Describe what you can do and for how long, how often, what help you need, and how long recovery takes. So, if you're able to sometimes do certain chores like laundry or shopping, you don't want to just answer yes, which is technically true but incomplete. A better answer might be, I do laundry when I feel well enough, but my partner carries it from the laundry room. Or with cooking, I microwave simple foods while seated, and my spouse prepares the rest of the meals. Or standing at the stove causes lightheadedness. Now, we don't want you to write, long essays about why you can't work. In our experience, lengthy statements rarely help, and specific details can get cherry-picked to support a denial. So we want your answers to be brief and focused on your difficulties. So yes with breaks, or yes, I have to pace myself, or I can only do this on a good day. There are no magic words that you need to include in the function report. Just remember to keep it succinct and include the difficulties that you're facing. So consistency. We want everything in the record to be fairly consistent. Excuse me. So it doesn't mean that everything has to look identical, but we don't want any red flags. We want a cohesive picture. I put here social media. Social media postings can be misleading. A photograph may not really tell the whole picture. So I recommend that you be a bit cautious about what you post publicly. I haven't seen this be an issue too often, but I think it's worth being mindful of what you put out there on social media. You should report any unsuccessful work attempts and include details about why they were unsuccessful or what difficulties you were having. There are third-party statements, much like the function report that you will complete. Social Security will send a questionnaire to a friend or family member that you've named who can comment on your functioning. Same advice applies. No excessive detail, but do describe your difficulty. Finally, one other thing I wanted to put in there is sort of a new consideration is the use of artificial intelligence. We are seeing people using artificial intelligence to create very lengthy documents that they then send to Social Security. Don't do that. It's not helpful. Also, I would be careful about what you upload to these chat agents because, you have very private, confidential information. You really don't want to put it out there in these AI agents that may not have to protect your privacy. Okay, now I'll turn it over to Moselle.
Now, I think this is actually one of the questions that someone has in the Q&A, but when to hire an attorney? This is partly based on your comfort level. You can definitely apply on your own, or you can hire an attorney from the outset. But many people do file the initial application themselves, and if they are denied, then decide that they'd better hire an attorney. So, people ask, well, why hire an attorney early on? Well, early help matters most where it's a very complex medical record. For also, if the work activity is in dispute, the onset date or your insured status is in question, or if you just feel like the forms are overwhelming and you want some guidance on them. So what do we actually do for a client? We make sure that the medical evidence is complete. We help develop it. We make sure that Social Security gets everything, and we might also guide you to let you know what we think is missing. We will also prepare you to testify if you have to go to a hearing. And of course, at a hearing, as I mentioned, we'll address the vocational issues that will help decide your case at step 5. We would be there to make sure that you are being properly questioned, that everything is being elicited, and that there is proper cross-examination of any witnesses. We also say that it's really important if you're denied to act promptly because the appeal deadlines are somewhat short. If you miss a deadline and you don't have good cause under the Social Security definition of good cause, that would mean that you have to start your claim all over again. So that can really delay things. And, as we mentioned, this can take a very long time. So there may be a long period of time where you don't have income coming in. In terms of attorneys' fees, which is a huge question, obviously, if you've stopped working, Social Security regulates attorneys and representatives and determines what fee an attorney or representative can charge. Our fee is set by Social Security and they approve it. So you shouldn't have to worry that someone is charging you too much. It should be standard across the board. Also, fees are contingent, meaning that a fee is generally not paid unless the case is won. Okay, and also these fees are paid from any back benefits that are owed to the individual. So that's also something that people would like to know. And if you would like to contact us, we have our contact information here. But let me back up just a step. I want to leave you with oh no, you can keep that slide. I'm sorry. I just want to leave you with one important idea is that your diagnosis is not the whole case. Some people are still not diagnosed. They don't know exactly what's going on, or they have that diagnosis, but that isn't going to necessarily mean that they're going to get approved. So what really makes the case is the records. So at every appointment, you want to make sure you are telling your doctors what's going on and make sure you're, being very specific. You may also want to, jot down all of your symptoms and hand that list over to your doctor. Sometimes doctors will just, type it into their chart or just include your paper in their chart. You also want to have accurate function reports. You want to make sure your records discuss your treatment response and that your limitations are documented. Like Alexis said, we often ask doctors or have our clients ask their doctors to complete questionnaires or write a letter, and they need to be specific. They can't just say, my patient is disabled and can't work, because that's a decision that they say should be determined by Social Security. So we want it to be very specific, saying how your functioning is. Another thing I want to mention is that if you do one thing after hearing us speak, I would recommend starting a symptom and activity log because that is also evidence. If you keep track of how often you are having near fainting episodes or actual fainting, if you are keeping track of how often you lie down during the day or for how long you need to rest and are not able to do your activities of daily living, this is evidence. I would also give this to Social Security, but also to your doctors so that they can see, because doctors often don't really know what your day-to-day looks like. So when they fill out questionnaires or write letters, they need to see this. Some people use just a paper calendar to track their symptoms. Some people will use an app like Visible. And we also have an app we can send to people. And so that's going to be important. I also tell people to pull their most recent medical records because you'll be surprised your doctors don't always write what you say. And there's often a lot missing. At times, there are things that are completely inaccurate too. So you want to know that because then you'll know what to do or you'll plan what to do. Okay? And a denial is not a judgment about whether you are ill, whether you have these medical conditions. It's simply going to be a stage in this process. So as we mentioned before, a significant number of claims unfortunately get denied, but are won at the hearing level. So as I mentioned, our information is here, our website, our phone number, and our main contact, which is our office manager's email address. Our main office is in Whittier, but we of course offer virtual and phone appointments throughout the state, and we do not charge for consultations. So now I guess I can turn it over to Sally or Emily and take questions.
Great. Yeah, thank you so much for that really informative presentation. We so appreciate it. We do have a number of questions, and we've been trying to go through them and organize, but also I will say that, let me just bring Emily back up here too. Okay, so we're going to go through questions and try to organize them, but
Yeah, I mean, if you'd like,
do
we
our
can
best.
just go through the Q&A questions one by one if you'd like.
But we also have some questions that have been pre-registered too,
Right.
so I'm happy
Okay,
to help present, but if there's anywhere
sure.
you wanted to start, we can also do that. No? Okay.
Go ahead.
So we do still have some questions about eligibility and the application. I think there have in general been a lot of questions about people who have became disabled when they were young before they were able to start working. Do you want to talk at all about the adult disabled child laws and in
Yes.
general what to do if you were disabled younger?
Sure. Alexis, do you want me to start with that one and you do the next
Sure.
one?
Sure.
Okay. So that's an excellent question. So again, there are the two different programs. So the first option is if you haven't worked or you didn't work very much and so you don't qualify for SSDI, you would qualify possibly for SSI. But that would, of course, be if you do not have more than the limit of $2,000 in your bank account or in assets, and so forth. But as Sally was mentioning, there is another program, and that's the Disabled Adult Child Benefit. If you have a parent who is either retired or on disability, him or herself, then you may be able to qualify for SSDI, and it's called Disabled Adult Child or DAC. And that benefit can be up to half of what your parent is receiving. You have to prove that you became disabled before age 22. You don't have to apply before age 22. You just have to prove it began before age 22. Between the ages of 18 and 22 is when you have to prove that you became disabled. There are some limits, though, with the DAC benefits. There are some little nuances there. For example, some of your work activity could if you had some but not enough, could disqualify you. It doesn't always, but it could.
Thank you. That's helpful. Um, let's see, other questions. We generally have a lot of questions about, the ability to work while applying. I know you covered a little bit of that. I think there are also still some questions about like, for example, if someone goes back to working full time and then maybe if it's more than the 6 month trial period, does that then ruin their chances of reapplying in the future should they become disabled again and unable to continue working?
No, I don't think that ruins their chances. It would be, a new onset date after they stopped working, so they wouldn't be able to get benefits for the prior period. But they certainly could file a new application after they stopped working the second time, um, so long as they're still currently insured for benefits.
Okay, thank you. We also had a question about I think this was in the grid question about what other types of jobs would people with dysautonomia be supposedly eligible for in the sort of, I can go back to the slide if that's helpful. But, do you understand?
Oh, what other jobs? Okay, would they typically
Yes,
identify?
criteria, yes.
Okay. Yeah, I mean, every case is different, but vocational experts are frequently going to identify some sort of sedentary job because they recognize that somebody may have lightheadedness, dizziness, balance problems. So they'll identify some sort of sedentary job or primarily seated work. I mean, there's so many of those jobs. If they're looking at, any data entry, secretarial, but if they're looking at unskilled, they'll come up with all sorts of jobs that you've never even heard of. For example, assembly work where you're sitting at a table and sitting on a stool and assembling small little parts. Um, you know, uh, Gosh, what are some others where maybe you're putting labels on things, where you are sorting things like that. I mean, there's just a lot of jobs. Some of them are completely outdated and Social Security recognizes that, but they still sometimes use completely ridiculous jobs.
Sure.
Right, like the surveillance system
Yeah.
um, operator. Yeah. Yeah, so
Interesting.
there are some jobs that and that's something that we often encounter in hearings is kind of cross-examining these vocational experts. Does that job really exist
Mm.
anymore? Because a lot of times they're basing their answers on very old data, and obviously the economy's changed, and jobs that existed 30 years ago just don't
Sure.
apply today.
Yeah, that's
Yeah,
good.
and I don't know if anyone has seen, but there have been articles in, say, the New York Times, et cetera, talking about this issue because they are using data from the 1970s primarily for these jobs. And obviously, technology has changed a lot of these jobs. So, or the jobs have been, sent overseas. So.
Well, that brings up a recent question in the chat here. Someone asked if you start content creation, such as TikTok, during the process of applying for disability, does that affect your application? Because that's definitely a job that wasn't around in the 70s.
Right, right. I mean, as Alexis and I would both say, I mean, the issue is, are you making money doing it is one thing. The other is, how much time are you devoting to it? So being self-employed, they have different rules. In general, if you earn more than this year, $1,690, they just say, hey, that's too much money to qualify. You're earning too much, even though we all know in California, uh, you know, you can barely live on that, or you can't. So, but then the issue is if you're self-employed, they don't necessarily just look at the dollar amount. I mean, if you're working on your TikTok's content and videos, 30 hours, 40 hours a week, it sure sounds like you could possibly work.
Okay.
And so they would disqualify you too. But if you don't have any earnings from it, then they probably uh, wouldn't be a red flag necessarily.
Mm. Okay, thank you. So how does Social Security work in tandem with employer-sponsored short and long-term disability?
Right. So if it's a private plan, that you paid into to be covered by it, it's not considered a public benefit, so it shouldn't cause an offset. So that's usually not a problem.
Okay.
And I would also add, there are different kinds of like LTD or long-term disability policies. Um, if you paid your employer part of the premium, but they're also paying some of it, if it's I should say an employer sponsored plan, that's where you run into the situation where that long-term disability insurance carrier, generally, from my experience, requires you to at least apply for Social Security benefits because they don't want to pay you as much. So if you get Social Security disability benefits, they're going to pay you a little less usually because you get Social Security. But I always tell people it is really important not just to do long-term disability, even though that's an option, because A, long-term disability does not come with Medicare, but B, uh, the LTD will pay you generally up to 2 years if you can't do your past work. But at the 2 year mark, they will use Social Security type definitions to say, well, now you have to prove you can't do other work too. Now, if you haven't been approved for Social Security at that 2 year mark, that insurance carrier might say, yeah, we were paying you for 2 years because we agreed you couldn't do your past work. But you know what? Now you have to prove you can't do other work, and we think you can. So if you get approved for Social Security, that really proves to them that you cannot work and your benefit for LTD should continue.
That makes me think of another question here. How does receiving like um, IHSS for being a caregiver, does that impact your ability to receive SSDI?
Right. That is a really common issue we find. Yes, and it's confusing sometimes because if you're living with a family member that you're providing these services for, it's generally not taxable. However, Social Security will still look at it as substantial gainful activity if you earn above that threshold of 1690 per month. Social Security is also going to look at how much time you devote to it. I mean, it's one thing if, you make yourself some food and, you make a little extra for your parent that you share with them. But if you're that might not be such an issue. But if you're having to bathe or lift someone or do heavy caregiving duties, that's really going to undermine your case too. I mean, if you're saying, you can't lift more than 10 pounds and yet you're caring for an elderly parent in that way. So, it, again, it's very fact dependent, but absolutely it can impact Social Security.
Thank you. Another question, does having retirement money in an IRA affect your eligibility and benefits?
Yeah, good question. So having money in retirement does not affect SSDI, but it does affect SSI.
Okay.
So it just depends which program you're applying for and are eligible for.
Okay. All right, another eligibility, let's see. I guess we've got some questions on the general application. Could you talk about the potential impact of medical tourism for assessment for the program?
So, because we don't have universal healthcare in this country, people sometimes do have to go abroad for medical care. I think the important thing is make sure you get your records. And, if they're not in English, they need to be translated and submit them. Ideally, we want people to have long-term treating relationships with doctors. So sometimes medical tourism is not conducive to that, but obviously some treatment is better than no treatment. But yeah, we've definitely seen people who've had to go to Mexico or other countries. But it can be difficult sometimes. So to get the records, so make sure you get them, and if possible, have them in English.
Thank you. Speaking of medical documentation, what do you recommend if a person's doctor has not been documenting their symptoms as reported due to any medical gaslighting, for example? Is there anything that can be done retroactively to correct this? I know sometimes we have people who, especially with POTS, where sometimes the diagnostic criteria, different doctors follow different diagnostic criterias. And then there is, with a condition that is predominantly female, often misunderstood. People often experience having medical records that don't paint the correct picture. What do you recommend in this case?
Yeah, that can be very difficult. That's why it is a good idea to get a copy of your records. Even if you aren't applying, you always want to know what is actually being said by your doctors. If the doctor did it unintentionally, that's the ideal situation because you could ask them to amend the records or at least write something saying that there were inaccuracies. We've had that happen. If the doctor actually doesn't believe you, is gaslighting you, etc., you need to change doctors because it doesn't, at that point, it wouldn't sound like they would be willing to change the records or amend them. But I think, you would want to make it clear that you believe that there are inaccuracies in your record and then see if there's another provider that you can see. That would be my recommendation.
Okay, thank you. Any advice on when you have doctors fill out their forms or letters on what they should be explaining, how much they should say? You touched on this a little bit in the presentation.
Right. So, I mean, doctors are busy people, so it's hard sometimes to get them to do anything in great detail. But, we want, we want things quantified. How much time can you do certain activities? And also, what are the medical findings or reasons for their opinion? Because if they just check off boxes, that's not so persuasive to a judge. They want to know what the reasons are that the doctor has. so again, we have questionnaires. Sometimes even Social Security sends questionnaires to doctors with that kind of, questions that they have.
Okay, thank you. Question, if someone is on leave and on disability insurance through their employer, when do you recommend that they start the process for applying for SSDI?
Well, if somebody's already on leave and they don't believe that they can go back to work before this 12-month time is up, then they can apply. As I did mention, sometimes if you apply too soon, that can be used as an automatic denial. So, it kind of depends. On the one hand, we used to tell people maybe wait until you've been out of work at least 4 or 5 months, because then by the time they get to the point of making a decision, it will have been 12 full months. However, given that these kinds of claims are very difficult and often go to hearing, you may want to just start as long as you and your doctor believe that you're not going to get this managed and go back to work for at least 12 months.
Question about gap in care. How long is considered a gap in care?
Yeah, I don't think there is any clear cut, timeline for that. But, you want to see doctors consistently. You're trying to build a record. So if you go, 8, 10 months without seeing a doctor and you're saying you have this really debilitating condition, it's not very persuasive. So I would follow what your doctors recommend, and try to see them consistently. But again, it's just kind of going to depend on your specific situation.
Okay. Do you have any recommendation for in general how often you should be seeing a doctor in terms of ideally for medical records?
Yeah, I would say every 3 months would be ideal. Yeah, anything more than that, and it's just it makes it a little harder.
Yeah. Okay. That's helpful.
Yeah. And sometimes I know people say that the doctors have nothing more to offer, so they stop seeing their doctors. But even if it's just to go to the doctor, document that you are still experiencing the symptoms that you have, I think that's important.
Okay. Thank you. Let's see other questions. What if you end up moving out of state? Does this automatically cause your application to be dropped?
No, that's not a problem. They may move your case to an office in the state where you live, but people move all the time, so it's not an issue.
Okay, great. And so how many years do you have to apply for SSDI after you stop working?
Well, so there's technically no time limit for the application. I mean, in some cases, I've seen people wait 10, 15 years. But the problem is you have to prove disability generally 5 years after you stop working, that date last insured. And if you wait too long, it just makes it a little more difficult to reconstruct the case. And you're going to need to get medical records going back to that date where your insurance then lapses, that date last insured.
Mm. And so in that process, can you get retroactive SSDI, or does it then just begin when?
Yeah, good question. So you can get up to 1 year of retroactive benefits from the date that you applied. So if you applied today, you could go back 1 year. Even if you've been disabled for 5 years, you're not going to get 5 years of retroactive benefits. The most they give you is that 1 year.
Okay, thank you. We just go through. All right, so let's talk a little bit about different appeals and denials. So I know you mentioned that a lot of cases end up going to hearings. So we had someone ask, can they still get disability if they've applied twice and got denied? Do those tend to then require a hearing?
I'm not sure if the question is twice on the same application or two different applications, but yeah, either way, you certainly can either apply again or you can continue the case through to a hearing. Um, yes, sometimes people will file an application and instead of appealing it, they file another application. Um, so we do see that, and usually we can um, continue the second application.
Okay. Is there anything that you recommend to increase the likelihood of being approved after appealing?
Well, I think in general, if you haven't already, speak with your doctors and see if they will complete some sort of questionnaire or write a letter being very specific about your limitations. That's usually one of the most helpful pieces of information that you can provide.
Okay, thank you. Um, so we had a question about how do you contest being denied disability benefits because you became ill or disabled after your coverage window?
Well, yeah, I mean, you can't. I mean, if you became disabled after that coverage window, you're simply not eligible for SSDI. But again, there is SSI in those situations.
Thank you. Okay, let's see. Apologize, just trying to go through all the different questions. We had someone say that they retired early due to disability and now receive a small teacher pension. How does that affect SSDI qualifications?
Okay, in the first part you said, I
They
didn't hear
retired.
you.
They
Oh, they retired.
retired early due to disability and now receive
Okay.
a small teacher pension.
Yeah, so you would just want to check that you have paid into Social Security. Some teachers do, some teachers don't. And so if you have also paid your Social Security taxes, then you would still apply for SSDI. And so that usually doesn't lower the SSDI amount. But we have some teachers who never paid in to Social Security at all.
Okay, thank you. Someone asked, can you become qualified for SSI while waiting for SSDI?
No, unfortunately not. They follow the same medical criteria and the same timeline, so it's not quicker to get approved for SSI than it is for SSDI. Um, so generally, you apply for one or both programs depending on what you are qualified for at the same time.
Yeah, and you may as I mentioned, there was that 5-month waiting period where they don't pay you anything for SSDI. You may get paid SSI for those 5 months. But as Alexis said, there's still the same process to get approved.
Okay, thank you. Someone asked, can you run out of Social Security funds if it's based on what you've contributed? Having to stop working due to disability means that you're no longer contributing. So is this counted against you?
I'm sorry. Can you repeat that? You said, can you run out?
Run out of Social Security funds if it's based on what you've contributed, if you've contributed less because you stopped working due to disability?
Well, I guess I'm not 100% sure I understand the question because Social Security so far has enough money to fund the program, if that's what the person is asking. However, the amount that they pay you is, they have a complex way of calculating it, and they will calculate that, and then that's what you would be paid if you're approved on a monthly basis. So, they might not be paying very much, but I'm not really sure what you mean by if you run out of funds.
I'm thinking perhaps they're referring to the way state disability is. In state disability in California, there's sort of a pot. There's so much money that they will pay out to you. And once you've exhausted that, you don't get any more state disability. And Social Security doesn't work that way.
I have to say, I find this all very confusing. These different programs, similar terminology too. So we're all very grateful that you are answering our many questions. And I am certainly going to be rewatching this recording. So thank you for all of the knowledge that you are sharing. Okay, another question. Could you explain how employer-sponsored disability also requires the sponsee to apply for Social Security? That makes sense.
Yeah, I mean, certainly, if it's like a long-term disability policy, they often do require you, as we discussed before, to file for Social Security disability. And that's what, in the in your insurance, in your contract, that's a requirement. And then they may terminate your benefits if you don't ultimately get approved for Social Security.
Okay. Thank you. We just had a question in the chat about the employer-sponsored long-term disability. So it sounds like that's often requires you to apply for Social Security, and then if you're denied that, they can stop the long-term disability coverage. Is that correct?
Right.
Yeah.
Right.
Okay. Other questions we've had, couple questions about working with an attorney. Do attorneys usually help with the completion of all the forms required?
Yeah, that's a great question. We do help. However, we like our clients to do a first pass at these forms and do the best that they can. And the reason is because if it looks like we have completed it and provided the answers, that's not ideal. We want it to look like it's coming from the individual who's applying. However, what's really important is we're going to review those answers and make sure that they are good, that they are not going to misrepresent your situation and will be helpful to the case.
Okay, thank you. We also had a question about the contingency fee percentage and whether that's applied to back benefits or to all monthly payments going forward.
So most attorneys will charge 25% of the back pay, and usually it's subject to a fee cap set by Social Security. Currently, the fee cap is $9,200, so the fee would not exceed that pay cap. Every now and then, Social Security raises the fee cap, but they don't do it annually. It's kind of hit and miss when that happens. And that's usually through to the hearing level. So there's no percentage taken out of your ongoing benefits.
Okay, thank you. Couple other questions. How does a work injury, like an ongoing work injury case, impact the SSDI process? For example, if the onset of dysautonomia symptoms were triggered by a work injury.
Yeah, so that would be the situation, for example, where somebody is applying for workers' compensation benefits. And that's where you have the situation where they will look at how much did you earn, and they'll look at the highest earnings in the last, let's say, 5 years before you stopped working. That's the most common way of doing it. Then they will look at what is 80% of what you used to earn. Now, if you get any benefit from the workers' compensation case, and then you get Social Security disability, that amount, those two amounts together cannot be more than 80% of what you used to earn. So if it is, that could reduce what you get from Social Security disability. And you also want to know if you have a workers' comp case going on, sometimes the workers' comp attorneys want to settle your case. You need them to know if you are planning on applying for Social Security or if you are already in the process of a Social Security application, because the way they settle the workers' comp is very important.
Right. There's certain language that your workers' compensation attorney needs to put in the settlement to minimize the impact on Social Security. And most workers' compensation attorneys know how to do that, but they need to know that you have a case pending or you're thinking of applying.
Okay, thank you. Someone asked about reapplying. So they've been on Social Security disability for about 4 to 5 years, and they read that they might need to reapply after 5 to 7 years after the disability determination to continue services. Is that the case? And can you talk a little bit about the reapplication and the disability determination process?
Yeah, so there's no limit on how long you can be on disability, um, but Social Security may decide at some point to take another look at your case and determine whether or not you still qualify. Um, so you don't need to do anything right now, but if they reach out to you and they want to take another look at your case, they're going to ask you about all of your medical providers. They may send you questionnaires about your daily activities. So it's very important that you've continued your treatment, obviously, because if you haven't seen a doctor in 4 years, that's not going to look good. Sometimes Social Security will decide that you're no longer disabled and they will terminate your benefits. Um, you can contest that, and we do represent people who are fighting those termination of their benefits.
A couple of last general questions. Can you talk a little about, does the employer long-term disability pay more or less than SSDI? Does it differ?
Yeah, I mean, unfortunately, we wouldn't have a specific answer to that. It really depends on the plan that the person has. So, some of them are the same amount of money. And so then if you get Social Security, you end up with just the same. Some LTD plans are very generous and they pay a lot more. So then they're just reduced by whatever you get from Social Security, and LTD pays the difference. So it really varies. It varies on how, your earnings, and the plan itself.
Thank you. And then sorry, one second. How does SSDI or SSI approval and benefits affect your tax status? Are you taxed on what they give you?
Um, Again, it sort of is going to depend on your tax situation, what bracket you're in, your spouse's earnings. So, you know, people who are, in lower tax brackets may not be taxed. People at higher brackets might end up paying tax on their benefits. So we always tell people to consult with a tax advisor.
Thank you. In terms of, so we have one question. Do you need your parent to consent to applying as a disabled adult child?
No, you don't, because applying as a disabled adult child, you're actually an adult at that point. So you have to be over 18. You just have to prove disability started before age 22. You will need to give Social Security some information about your parent, though, such as their Social Security number, and their full name. It may be that just their full name is enough. And of course, they'll probably want a birth certificate so you can show that you are indeed the child and eligible.
Okay. Thank you. You had a question about so can you please discuss how to navigate if you hope to return to work once you get proper diagnosis and treatment, hopefully with retroactive SSDI?
Right. So I think most people hope to return to work. And I always encourage people, if you can go back to work, that that's always preferable. But you can certainly apply and hopefully get approved. And, if some point after you're approved, you want to return to work, there is a program. It's called a trial work period. Where you can test out your ability to work without losing benefits. There's a 9 months total that you can work in any 5-year period once your benefits have started. And if you work less than 9 months, your benefits will continue. After the 9 months, your benefits will stop. There are some limitations on how much you can earn during those 9 months as well. There's also a possibility that you might return to work and become sick again, and you can get your benefits reinstated. So certainly there are different options out there, and it's definitely something that we're always happy to explore with people if they get to that point.
Well, you guys have answered so many questions and provided really helpful information. We really appreciate it. If we didn't get to your question today, I apologize. I tried to answer generally or to ask general all of the questions that tried to cover all the topics in a general way. I'm really grateful for everyone who asked questions too. It was very informative to see the questions that you all have. And yeah, if you didn't get your question answered and you are seeking and help from this, I hope you'll reach out to Moselle and Alexis. Want to thank both of you, Alexis and Moselle, for providing all this fantastic information. Thank you so much for being here.
And thank you for having us.
Yeah.
Thank you.
Well, thanks everyone for joining us, and I hope you have a wonderful rest of your day. We'll go ahead and stop the webinar now, but yeah, thank you all so much.
Thank you so
Thank
much.
you.
Bye.
Bye.
Bye.